Good morning to those of you who are on the West Coast, and good afternoon to you who are spread throughout the country. Welcome to the Housing Rights of Survivors with Disabilities. We appreciate you attending. I know that most of you have attended many webinars, either given by us or others, but I just want to go over the control panel for those of you who have are not familiar with GoToWebinar. And the most important thing for you is the question box, which is right there. You can see that on the side of your screen, and periodically as we go through this webinar, we will be asking you questions, and you can type in the answers here. Or if you have any questions about what we're saying, you can also type that in. And if it's something that is immediate in terms of that you're not hearing us or something like that, we will try to address it as soon as we can. If there's substantive questions, hopefully we will be able to address them as we move along through the presentation. Otherwise, we will answer them at the end, with reserving some time for questions. And then perhaps if we still don't get to your questions, we'll try to address them in individual emails to you. Just a little bit of housekeeping. We emailed materials to all of the registrants this morning, and we'll be emailing them again after the webinar along with evaluations. We hope you do, in fact, turn in your evaluations. They're very helpful to us. These materials and the recording will be posted on our website, nhlp.org, and evaluations and CLE certificates will be emailed after the webinar. Just so that you all know who is sitting at their desks listening to this, and so that we know who you are, we have two polls here that we would like to launch now, just to get a sense of who you are. So, Francis. Are you able to launch this poll? Okay. I think we can close the poll now. As you all can see, many of you, the vast majority of you, have some knowledge of the laws with respect to reasonable accommodation. Some of you are new, and some of you are very familiar. So I'm hoping that those of you who are very familiar will be asking the tough questions, and perhaps even when we come to questions along the way, we'll be providing some answers to those questions that we can share with everybody. Can we launch the second poll now? Good. I think we can show the results. As you can see, it's quite a mix of people who are attending this webinar. Nearly 40% are transitional housing providers, 22% are legal assistance for victims, 6% are state coalitions, 6% are state, and then 28% of you are other. So thank you for taking the poll. Again, many of you are familiar with the National Housing Law Project, but for those of you who are not, we are a national technical assistance provider for the Office on Violence Against Women grantees, and we're available to provide training, materials, and support on housing issues affecting survivors of domestic violence, sexual assault, stalking. For more information, you can go to our website. We, in addition to providing these webinars, we also provide a monthly newsletter to OVW grantee recipients, and we post that newsletter on our website. I want to introduce at this point in time Navneet Grewal. She's a staff attorney with the Western Center on Law and Poverty, and she is going to be one of the presenters here today. She has worked on reasonable accommodation issues for a number of years as a staff attorney at the National Housing Law Project, where I am working now, and as a staff attorney at the Western Center on Law and Poverty. And she also worked on issues relating to survivors and the implementation of VAWA. And I am Catherine Bishop. I'm a senior staff attorney at the National Housing Law Project and have worked also on reasonable accommodation issues and VAWA. Kim Penderson, staff attorney at the Mental Health Law Project, was going to join us today, but she woke up this morning and emailed me and said she has totally lost her voice. So Navneet and I are going to do our best to fill in for Kim, and we hope that even though we won't have her knowledge on the call, that we will in fact give you what you need on this webinar. So what are we covering today? We are going to be covering the common housing issues that survivors with disabilities face. We're going to be covering the housing rights and protections available for those survivors that have disabilities, and how to use reasonable accommodation laws to advocate for survivors' housing needs, those survivors who have disabilities. Just a little bit about the interrelationship between domestic violence, sexual assault, and disability. There is a fact sheet in your materials that we sent to you this morning that has the information that's on this slide and also has more data and more information. But as you can see, the studies have shown that women with disabilities are at a 40% greater risk of violence than women without disabilities. That women with disabilities are much more likely to have a history of unwanted sex with an intimate partner. That 80% of the women and 30% of the men with intellectual disabilities have been assaulted. And that children with disabilities are more than twice as likely to be physically abused and more than twice as likely to be sexually abused than children without disabilities. So that there is, unfortunately, very much a link between domestic violence and disability. So what are some of the tactics that abusers use to maintain power over survivors? They do that through control of medicine, medical equipment, mobility aids, disability services, denying those or controlling those services or controlling access to them, denying access to family members and friends, limiting communication devices and services, denying access to transportation, and also amplifying fears of social bias or stigma surrounding people with disabilities. Those are many of the common ones. We're wondering what other tactics you might have seen or you might have encountered in your practice. And if you've encountered things that are different than what we have listed up here, if you could type them into your question box to share with others, that would be terrific. I'll wait a minute to see whether there are any questions included in that. Well, here's one that came in as financial withholding of money, threatening removal of health insurance, establishing power of attorney over the disabled person, threatening to abuse the dog or service animal, and just generally use of fear. I think all of those are clearly also common ways that the abuser tries to control both the survivor and the survivor with domestic that has disabilities. So what are some of the obstacles that women with disabilities and survivors encounter? Certainly there, in terms of finding housing, common issues are poor rental, poor credit, well, that's a poor rental history, a poor criminal history due to the disability. There's also just the mere lack of units that are accessible for people with, especially with mobility impairments. Refusal to rent to survivors who have a service animal. And then stereotypes by landlords about individuals with disabilities. Some of those stereotypes are that people with disabilities are less credible. Some believe that they attract abusers. Inability to find an affordable unit in a safe neighborhood. And insufficient income to pay for the rent. There are also obstacles for maintaining such housing. Survivors need, and those obstacles are that a survivor actually needs a transfer, that the housing provider says that it lacks another accessible unit, or refuses to provide that other accessible unit. The survivor seeks a modification of the unit to make the apartment physically accessible. Or maybe the survivor needs additional safety measures that are tailored to his or her particular disability. There's certainly provisions that, in terms of obstacles to maintaining the housing, is that the person with the disability never had a pet and now has a supportive animal. If the individual lives in subsidized housing, that individual may be absent from the unit during hospitalization or treatment. That may threaten their housing. And the survivor needs disability-related changes in administrative policies or rules, in addition to the ones mentioned above. Certainly, I'm assuming that you often see disability in evictions, and a survivor may be unable to fulfill the lease or program requirements due to disability or fear of abuse. And some of those examples include being unable to leave the unit, to attend meetings if it's subsidized housing at the provider's office, an inability to exclude the abuser from the unit, a failure to pay the rent on time due to conditions related to the disability or related to the abuse. And sometimes the survivor with the disabilities may exhibit disruptive behavior that's caused by disability-related symptoms, and that forms the basis of an eviction. Now I'm going to turn this over to Navneet for the next session.
Hi, everyone. Give me a second while I get my screen up here. Okay. So one of the things the main thing that we're going to be talking about today is one of the tools to help ensure your clients can either access housing or stay in their housing is the right to reasonable accommodations. What is a reasonable accommodation? A reasonable accommodation is a change in a rule, policy, practice, or service that may be necessary to allow a person with a disability the equal opportunity to use and enjoy a dwelling. So that's, that's the technical definition. And one of the things that often comes up, a lot of folks are familiar with physical changes that need to be made. And I'm going to distinguish the accommodations a little bit and talk about the physical changes as reasonable modifications, ramps and handlebars, but talking about accommodation as real policy changes, and this can often be a little bit more confusing for housing providers to understand and really grasp the idea of, because the common refrain you hear from people who are unfamiliar with the concept is, but I need to treat everyone equally. So I often hear people, housing providers who are saying, well, in order to comply with fair housing laws, I can't treat you differently because of your disability, when in fact a person with a disability may need to be treated differently with respect to a specific policy in order to have at least, a little bit more of an equal opportunity to access that housing. And then I'm going to move to the next slide and having a little bit of trouble. There we go. Okay, so where does the right for a reasonable accommodation come from? It arises out of a number of fair housing laws. The first place you really saw it was in Section 504 of the Rehabilitation Act, which was enacted in 1973. Section 504 only applies to housing that gets federal financial assistance, so that's going to be public housing, any of the privately owned housing that gets federal money. And if people have specific questions about what's covered by that, I can go into that in more depth later, but only if you have the question. Otherwise, we have a lot to cover. The Fair Housing Act in 1988 was amended to include people with disabilities, and within that was the right to reasonable accommodation. That's going to apply to almost all types of housing with very limited exceptions, so private housing for the most part. The ADA also includes a right to accommodations. You usually don't see that raised as much in housing because we have these two other federal laws that really cover the majority of housing, but often it's raised as a parallel. And then you also want to look at your state laws because sometimes they're more expansive in how they've interpreted the right to reasonable accommodation, and I'll give an example or two later of how California's Fair Employment and Housing Act is a little bit more broad than the federal fair housing laws providing for reasonable accommodation. I'm not entirely sure why my highlights are still showing, so I apologize for that. When a qualified person, so when must a housing provider grant a reasonable accommodation? So if someone is asking for a change to a policy, I'll give an example so that it's more clear. Say there's a no pets policy, and a person with a disability needs their emotional support animal. So the person can request a reasonable accommodation to the housing provider. And when does the housing provider have to grant that? Do they have to grant every accommodation that's requested? The rule is really that it's when a qualified person with a disability makes a request. So that's key. The person has to make the request. And then that request needs to be necessary, and reasonable. And those are all sort of terms of art that I will get into detail about in a minute. But if you've met those requirements, then the housing provider has to grant the accommodation. There's a couple defenses that they might raise, which I'll also talk about if they still refuse to grant the accommodation after that. I'm going to really quickly try to get rid of these highlights because they're distracting. They're not going away, though. Oh, there we go. Okay, thank you. Okay, so unfortunately, we've now, sorry for the technical difficulties. We've gone. Okay. So who is a person with a disability for the purposes of reasonable accommodation? I'm going to talk about the federal definition because that is the one that's going to apply to all of you, but I encourage you to look at state law as well. So under the federal definition, a person with a disability is any person who has a physical or mental impairment that substantially limits one or more major life activities. So what is a major life activity? That's going to be stuff that you do every day: breathing, walking, talking, cooking, eating. Things like that are major life activities. Substantially limits, I don't know of a ton of case law under the Fair Housing Act that really gets into the substantial limitation issue, but I do know that this is one of the areas, for example, that California's law is more broad in that it doesn't have the substantial limitation caveat to the definition. It's just that the physical or mental impairment limits one or more major activities. Then the second prong is that a person, so this is an or proposition, is that the person might have a record of such an impairment. So the person may not actually have that disability currently. Or, you know, there was one case out of Chicago where the person didn't actually have a disability, but the housing authority had on file that the person had a disability and believed the entire time that the person had a disability and treated them, discriminated against them based on that record. And then finally, a person may meet the federal definition of disability if they are regarded as having such an impairment. So the person may not actually have a disability, but because of people's biases and perceptions, they may regard the person as having a particular disability. One example that was particularly, I think, egregious that came up before was people assuming based on people's a couple's sexual orientation, a same-sex couple, that they had HIV or AIDS, and so neither did, but the housing provider treated them as such. And so they would have also fell under the federal definition of disability. So this is going to be really different than and much more broad than the definition that you're using for, say, helping people get SSI and other types of benefits. And in housing, it's also important to note that this definition is different from the definition that's required to get into housing for people with disabilities. It is also more broad. So the placing of this slide is a little weird, but there are ways that even if a person meets all of the criteria of the definition of a person with a disability, they might not be able to get a reasonable accommodation. And one of those, the primary reason that a person can't get cited is if they pose a direct threat to the health and safety of others. And such a threat must be objective and not subjective. So it can't be based on fear that because a person's behavior is odd, perhaps they have a mental health disability and people are scared of how that projects. That is not enough of a basis to say you're not eligible for a reasonable accommodation. There's actually a really good case out of California that talks in depth about this. It's called McAllister versus Essex. And it goes into depth about sort of the objective versus subjective nature of a direct threat and that it really has to be objective. So in figuring out if a person may be a direct threat to the health and safety of others, a housing provider needs to look at the nature, duration, severity of risk of injury, probability injury will occur, and any accommodations that could eliminate the direct threat. So you need to look at basically how serious is the risk of this threat? Is it likely to happen? And even if there is a serious threat, is there any accommodation that could be made that's really going to, and I'm not sure why the slide says eliminate, it should be mitigate. So to make it a minimal threat because you can't always necessarily eliminate the threat. And I would recommend that people read Boston versus Bridgewater's versus Boston Housing Authority for a really in-depth and good discussion on this issue as well. To be very clear, this is not the same standard as actual and imminent threat rule under VAWA. So there's different standards, slightly different, and I know there had been a lot of discussion about what actual and imminent threat means under VAWA. And so we're not going to get into that issue, though, today. What we're really focusing on is the reasonable accommodation direct threat. So we have a question for folks if you want to enter your thoughts into the questions section so that we can read them later. What arguments have you made when a landlord has alleged a direct threat? Were you successful? And so I will move forward with the slides and talk a little bit about your responses when we get to the end of this section. Another exception to the definition of who is a qualified person with a disability for the purposes of reasonable accommodation is someone who's currently using illegal drugs, controlled substances. So I highlighted current here, and I'm scared to use the highlighter tool now. But I really want to emphasize that it's not someone who in the past has been using drugs. It has to be someone who's actively. And there are a number of different situations. People have been able to argue that, someone who hasn't used drugs for the last month is not a current illegal user of a controlled substance. Some have 6 months. So it really ranges, but some of the things to look at are whether they've successfully completed a drug rehab program, whether they're currently in a rehab program, and are otherwise sober. And again, all of these exceptions are pretty narrow. I want to be clear that even if someone is using a controlled substance, a lot of folks have been successful in getting a reasonable accommodation that's totally unrelated to the drug use. So, for example, if you have a mobility impairment, simply because you're using a controlled substance does not mean that the landlord can say, no, I'm not going to give you a parking space closer to your unit because you can't walk that far. So you should still go ahead and make a reasonable accommodation request. Someone's currently using a controlled substance if the policy is completely unrelated to the use of the substance. Another common question is, does medical marijuana fall into illegal use of a controlled substance. The head office of general counsel issued a memo a couple years ago. Well, it was the second memo it had issued, but it includes really extensive analysis of basically detailing why HUD does not allow for people who are using medical marijuana to get a reasonable accommodation to use that medical marijuana. It basically comes down to the principle that under the Controlled Substances Act federally, marijuana is still illegal whether or not your state has legalized it. I know here in California there's also some case law saying that in the employment discrimination context, a person is also not entitled to a reasonable accommodation to use medical marijuana. Okay, so you've established that your client or yourself or whoever you're asking for the accommodation for is a person with a disability, and none of the exceptions apply. Then the next thing you need to do is to say that this change that I'm asking for, that we're asking for, is necessary. So sometimes you'll have people come in and say, I really want this policy change, but it doesn't really have anything to do with their disability. To make just an obvious example, say someone wants a ground floor apartment but doesn't have any disability that prevents them from walking up the stairs. That is not necessary. So what you really need to have is some connection between the disability and the requested accommodation. So if you wanted a ground floor apartment, something that might have a nexus to that is that the person does have a mobility impairment that prevents them from getting up the stairs. And so that would be a nexus. These often get a little bit more complicated, and if we have time at the end, we can talk about some of the more complicated situations where it may be a little bit hard to demonstrate that nexus. And then in order for something to be considered necessary, it also needs to be something that enhances the tenant's use and enjoyment of the unit by ameliorating the effects of the disability. I wanted to highlight a couple of things about this definition. So this is one that was developed in the case law. I think it's a case called Bronk versus Eineken out of the Seventh Circuit that's been followed by most courts with a few exceptions. But the key to this is that it's not a change that completely eliminates what the problem was, but it's one that can make the person's use and enjoyment of the housing better. So sometimes a housing provider might say, well, this tenant doesn't really need this accommodation because you're not going to be evicted if I don't give this to you. You're not going to be out on the streets if I don't give this to you. And that's not the standard. It has to be that it has to be the same an equal opportunity to use the housing. So, it's easier, I think, to give the example of a physical change of, perhaps you could have cabinets that are really high up and never use them if you're in a wheelchair, but that doesn't give you the same type of opportunity to use the housing as if you had the cabinets lowered and accessible. And it's, I think, the same thing with an emotional support animal as an accommodation. You're not necessarily going to be evicted. You're not necessarily going to have to leave your housing if the landlord denies waiving a no-pet policy to allow an emotional support animal. But the ability to stay in that housing and have appropriate treatment for that particular mental health condition that the person may have is not the same as other people who don't have the disability.
Navneet, there was a question about what was the name of the case again? You said it was Bronk versus
Eineken. I think it's spelled I-N-E-I-C-H-E-N.
Thank you.
And it's in the outline. Did you send out the outline, Kathy?
I did not send out the outline that's posted on our website. No, I did not.
Okay. Okay. Well, then there's an outline posted on NHLP's website that includes the citations to all of the cases that I've mentioned so far. Okay. So, you determined your client has a disability. They have a real need for this particular accommodation. It's necessary for the use and enjoyment of the housing. Is it a reasonable request? What does reasonable mean? Reasonable means a very specific thing. It means either that the request does not impose an undue financial burden or administrative burden on the landlord or housing provider, or that it does not fundamentally alter the nature of the program. So what's an undue financial or administrative burden? An undue financial burden, one of the things that the HUD regulations does is it gives 4 factors to consider. I don't necessarily like always raising these 4 factors, but HUD has them in their regulations, is to consider the benefit to the tenant, the cost, the financial resources, and the availability of a less expensive accommodation. So this is really going to be fact-specific. If you're a small mom-and-pop housing provider, say you have 6 units, you may not have the financial resources for a certain accommodation that a huge multifamily housing provider does have. So it's really fact-specific. A number of circuits, I know the Ninth Circuit has really good language in some cases. Again, they're in the outline. I could tell them to you now. If you really want to know, you can put that in the questions, that say that there will be some cost to reasonable accommodation. So one of the examples from the Ninth Circuit case, McGarry versus Portland, is the person couldn't mow their lawn in the way that the city had required, and asked to waive the fine that was imposed on people who didn't maintain their lawn in a particular manner. And so the person had asked for a reasonable, asked for that waiver, and the court said, there will be some cost to reasonable accommodation. Just some amount of cost is not automatically an undue financial burden. And so then the other thing that would make the other prong that could potentially make a request unreasonable is if it fundamentally alters the nature of a program. So say you have a client who needs transportation assistance, but the housing provider doesn't provide transportation assistance. That would be a fundamental alteration of the nature of the program. So your client has done all these things, demonstrated that they're a person with a disability, asked for an accommodation that's necessary and reasonable. Then how do you actually make the request? The request can be done in many ways. There's no magic way to do it. It can be oral or written. In general, it's good practice to make the request written. But basically, a person can say to the housing provider, I really need this change. I have a disability. Can you make some sort of change to accommodate me? They don't need to say any particular magic word. They don't need to say I'm asking for a reasonable accommodation. It doesn't have to be put in writing. So even if the housing provider says, okay, well, if you want some kind of change, put it in writing, tell me exactly what you want, but the tenant never puts it in writing, it doesn't matter. The accommodation process has already begun. Once someone has made clear that because they have a disability, they need some type of change, the housing provider has to begin acting on it. but they're generally going to be good practices and not good practices. So if the tenant has a disability, it should be make sure that they have one. If it sounds like a person's just asking for a change and you have no idea why that change is being asked, then that does not suffice. But the tenant does not have to say what the name of the disability is. The only thing that they are required to provide is what the symptom that necessitates the accommodation is. And that's only if it's not obvious. I'll talk a little bit about verification of a disability and then get into the different sort of scenarios you might have with that. Then when you make a request, you also want to say that you're looking for an accommodation and what that accommodation is. Again, a person may not necessarily know immediately if they're unrepresented what that accommodation is, but the process should at least begin by then. As a good practice, what you want to do is say exactly what the accommodation is the tenant is looking for. And then it should also, again, as a good practice, state that how it's necessary, how that accommodation is necessary to help the person either access or stay in the housing. So now I think we have a poll question. And was Francis going to do the poll?
Yes.
Okay.
So the question is, when should a request for reasonable accommodation be made? And this is one that you can select every answer that you think is right or no answers. So here are the answers to the poll questions. I'm not certain whether you can see them, Navneet, or not. The vast majority of you, and this is not really a trick question. There's a variety of answers to this question, but the vast majority of you said as soon as possible. 26% of you said only if there's proof of a link between the disability and the need. 11% said that's only when a disabled tenant knows that the accommodation that she wants. And nobody said that only when the disabled tenant has proof that she's disabled. And then 50% of you said depends upon the circumstances. So what do you make of these responses, Navneet?
I think that they're all right. I would go with depends on the circumstances. You know, I think as soon as possible is probably the best answer, but you also don't. I don't think you need proof of the link between the disability and the accommodation, but it's usually a good idea and good practice to make sure you have all of these things lined up. Because the housing provider may be able to ask for them, and we'll talk about verification in a minute. You know, one of the things is that you can always get a reasonable accommodation until what a court has called the proverbial last minute, so even after someone's been evicted, until basically there's no opportunity to keep the housing. But you don't want to get a client into that situation, right? So it's best that as soon as it seems like there's a legitimate claim for reasonable accommodation to ask for it and get the process rolling, since in most cases it is really an interactive type of process. Okay, so moving forward. As I mentioned, so once a person's asked for the reasonable accommodation, the housing provider can potentially ask for verification of the disability. There's a few different scenarios that you might see. First, if a person's disability is obvious or known and the need and the need for the accommodation is also obviously connected to that disability, then the housing provider should not ask for any more information. So basically you have someone who's just written a letter that says, you know, I have, you know, I have cancer, I'm undergoing cancer treatment, and my drugs are making me extremely drowsy. Can we postpone my annual inspection for public housing until I'm done with this round of chemotherapy? And it's very obvious that the person is very drowsy and undergoing chemotherapy. The housing provider should not be asking for more information. They should agree to postpone an annual reinspection for the public housing, you know, for public housing. And then, so what's another scenario? The disability is known or obvious, but how that's related to the accommodation, the need for the accommodation, is not so obvious. Then the housing provider should ask only for the type of information you would need to verify the need for the accommodation.
Can you answer this question sort of in the context of a pet? Somebody asked that question sort of in the context of a pet, of how you link the need for a pet to the disability.
Mm-hmm. Mm-hmm. Okay, so yeah, so say you have someone who has a particular mental health disability that requires an emotional support animal. So say someone has chronic depression. This is a place where usually what housing providers will want is a doctor's letter. It does not have to be a doctor's letter. It could be a letter from any knowledgeable professional. There's probably in practicality a hierarchy of what housing providers consider a solid evidence, and that's going to be, you know, a doctor's letter, a psychiatrist, therapist, a social worker, but really anyone who's knowledgeable can attest to the need for the support animal. Was there more to that question?
No, that was really it. That's the way I understood the question as it came in.
Mm-hmm. Yeah, so often the types of letters you'll see is a doctor saying, you know, so-and-so has a disability, doesn't have to say what it is, especially sometimes, you know, the tenant doesn't necessarily want to say exactly what the disability is because some may carry more stigma than others, or just because for privacy. And then it will say, you know, the support animal helps keep so-and-so calm, or in X situation, the support animal will do this. So often the letters will actually say how the animal helps. And another thing that sometimes is included is not only how the animal helps, but how the person would be affected if they lost the animal, which can often be the harder thing. So say you have three dogs, and the housing provider says, well, why can't you just have one emotional support animal? And then sometimes you'll need to see letters saying, well, if the person is so attached now that it would have a devastating effect on his or her mental health. And then the third type of situation is if neither the disability nor the need for the accommodation is readily apparent, then the housing provider can ask. And I'm not sure why the slide says should, because it can ask for verification of both the disability and the need for the accommodation. In any of these situations, the housing provider does not have to ask for anything. They could just take the tenant's word for it. This is more of when they're allowed to ask.
Some of the reason, though, that the reason that the should was is that we have on the phone here, we have both people who are representing individuals who have disabilities, and we have people who are transitional housing providers, so that they may be in a situation where they're looking and trying to determine what, if they have sufficient verification to move ahead and provide the accommodation.
Yeah, and I would just warn that it's not if you don't feel that it's necessary, you kind of understand the accommodation, you don't need to get written verification. I would say the should is for when it's really not very apparent. Okay. So what if, all of these sort of elements have been met? There's no defense to any reason to deny it. What happens? So if the housing provider finds that the requested accommodation is not reasonable, its obligation doesn't end. The provider must engage in an interactive process and try to determine if there's another feasible accommodation. So say you, continuing with the pet example, say a person asked for an accommodation to have 6 chickens, and because it does help their emotional support, their emotional well-being. The housing provider says, okay, well, that would put us in violation of the health and safety code, and so that would really be a fundamental alteration of our services. We need to be in compliance with the health and safety code. And so you come back and say, well, 1 chicken could be okay. And so there's a negotiation could happen even if you find that the request is unreasonable. And I do want to be clear that the interactive process, it's not for just if the housing provider doesn't like the particular requested accommodation. It really has to be if it's unreasonable, because the person with the disability is really in the best position to know what accommodation they need. So if no alternative accommodation is agreed to, it's treated as a denial of the original request. So just because there was some type of interactive process, at the end of the day, if there's no accommodation made, it's still a denial. And just as a practical matter, sometimes when you're in federally assisted housing, the Section 504 hearing is what the housing provider will use as their sort of medium for the interactive process. Sorry, I'm flipping to the right page. Okay, so we have a hypothetical here. Carol is a survivor of domestic violence. She obtained a restraining order and her husband moved out. Her doctor, who treats her for anxiety and depression, suggested that she would benefit from the companionship of a dog. He also believes that the dog would make her feel more safe and secure. The apartment complex has a no pets policy, and she's been served with a notice of eviction. So the question is, and again, you can put this into your question box, what if a housing provider wants proof of vaccination for the dog, limits where the dog can go on the property, and limits the size of the dog or requires it to be muzzled at certain times? So they say, okay, you submitted this request for accommodation for the no pets policy, but I want all of these restrictions on it. Is that legal? Give people a second to respond, and I'll see what they say.
While you're waiting for that one, you might go, there's one here when you were asking about whether or not anybody had ever been able to get somebody for an accommodation when there was a direct threat. And there was somebody who wrote in and said that they were able to get an accommodation for someone who was disturbing other tenants due to a mental disability, and that she was trying to get into other people's units. She was banging on the walls in the middle of the night. And what the advocate did is she worked with the public housing social worker, and just meeting with him once a week, the social worker was helping controlling her symptoms, and they did not evict her, even though they certainly could have perhaps met the burden showing that she was a danger to other residents.
Yeah, that's a really good example. Okay, so we've had a couple of different answers, going from only the vaccinations and turn to the interactive process. Some people saying that it seems like it may be a reasonable request. So, yeah. Sorry, I clicked on that. So, with pets, it's a little complicated. There's been a bunch of recent litigation, and Kim was really the expert on this issue, but I will try my best to answer it. And if she has anything to add to this, we'll send that out after. Proof of vaccination is probably okay under, I've worked with a few people who have tried to get an accommodation without a proof of vaccination, and it's been really difficult to near impossible. But in terms of limits where the dog can go on the property, and the limits of the size of the dog and the muzzling, that's inappropriate. An emotional support animal should really be considered the same thing as a service animal, and this is sort of a terrible way to put it, but legally, animals that are needed to assist with a person's disability are sort of looked at as medical equipment. And so all of these restrictions are likely to be inappropriate in terms of the limiting where they go on the property, the size of the dog. The one difference that I would between a service animal and an emotional support animal is that for a service animal you may have to provide proof of training, but that training may have been done by the individual themselves. It just needs to comply with service animal training, whereas an emotional support animal does not need to have any sort of proof of any type of training.
And one thing that I would add in terms of some of these other limitations that are on the animals, it's going to depend upon what the living circumstances are like. So that, we didn't say whether this is a single family home someplace, whether the person is renting it, how crowded the housing is, so that it may be that some of the restrictions, depending upon the nature of the housing, or for instance, like, as I said, some of the people on the call are transitional housing providers, and so that, people are in very close quarters, so that depending upon the circumstances, whether or not the dog has shown any kind of behavior that might be considered dangerous or aggressive towards other tenants, maybe the muzzling does come into play. And that just is really emphasizing that reasonable accommodation requests and responses to it are all so intensely fact-driven. What is the size of that dog? What's the history of that dog? What are the circumstances in which that animal is being placed?
Yeah, and so I think it's important to go back to that the same analysis will always apply, that is a really helpful point. That if the dog has demonstrated that they've been a threat to others, then it may become reasonable to have these other restrictions put into place. There are a few other questions that people had in relation to this. If a person has a diagnosis under the Disability Act, it's that the no pet policy can't apply. There are exceptions to no pet policy in assisted housing. So that's right for assisted housing, but you may have a private housing provider that has no pet policy that's not covered by by that rule. Limiting the breed is a really complicated question. There probably shouldn't be under any of the legal analysis. I mean, going back to what Kathy said, you know, if the dog itself has been aggressive, then it may be reasonable to request some of these things. But I know some folks who have had really bad luck in pursuing a claim that limiting the breed was inappropriate. In one case that I'm thinking about, but one of the issues had been that the neighbors were really frightened of this particular pit bull. But that's something that has not been, there's not a lot of case law on the breed. And I think it will generally go back to the direct threat issue, affecting how it affects the health and safety of others. Okay, so I am going to turn it over to Kathy again, and we'll look at some of your other answers and questions and come back at the end to help try to answer some of those.
Thank you, Navneet. Oops, I am. Why is this not moving? Oops. Oh, shoot. Sorry, everybody. I want. Oh, yeah. Excuse the delay. So we're on the slide on Section 504. As Navneet previously said, entities that receive federal financial assistance are covered by Section 504. That includes housing authorities, HUD multifamily properties, domestic violence shelters. And with respect to domestic violence shelters, there's a discussion of the applicability of 504 in the materials that we provided to you, where it goes over all of the Fair Housing 504 civil rights laws that are applicable to domestic violence shelters, and also to transitional housing providers also. The one exception to this, at least in terms of the group of housing that people consider sort of like subsidized or assisted, is low-income housing tax credit properties. So that if you're trying to transition somebody out of your transitional housing unit into tax credit housing, and there's no additional HUD subsidy on that, no additional federal assistance on it, the only thing that it is a tax credit property, then 504 doesn't apply. And of course, there are a couple of exceptions to that, because after some tax credit properties get federal assistance because they got special grants after the financial crash, and that was considered community development block grant money, and then some tax credit properties, when they're being developed, will get local money added in to make the tax credit work. But those are relatively rare exceptions. So what does 504 require? It requires affirmative steps to make that federally assisted housing accessible to people with disabilities. And there are heightened obligations to make sure that all people with disabilities can use the federally assisted housing. 504 in particular provides that no qualified individual with a disability shall be excluded from, and I'm quoting, shall be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance, or any program or activity conducted by an executive agency. And that's the extent of Section 504. It's a very brief statutory provision, so that all of the rules from it are derived from either case law or regulations implementing that statutory provision. So that what does a housing provider need to do to comply with 504? It's required to do a self-evaluation, and for, let's say, housing authorities, they can do that as a separate self-evaluation plan. They could include that in their annual plans. Housing authorities are not required to, but HUD encourages them to yearly review their self-evaluations. They are certainly required to make any assessment that they made and any transition plan, and by transition plan I mean when they initially were required, when housing authorities were initially required to conduct a self-evaluation, and if they found that they didn't have a sufficient number of accessible units, then they were required to establish a transition plan, in other words, a plan to achieve program accessibility. And that initial self-evaluation, hopefully it has been updated, and any transition plan must be accessible. And the HUD Department of Fair Housing and Employment Opportunity, or Economic Opportunity, says that if they ever come in and do a compliance review, that they will be requesting copies of these documents, so that most housing authorities, most owners of subsidized housing do have a self-evaluation plan. Another thing, at least in terms of possible steps for compliance, is to do an assessment of the needs for accessible units. Now, a housing authority can do that in terms of looking at the private market and saying, okay, we know we have so many people who need vouchers or be given vouchers. They will need an accessible unit, so that we're going out and we're trying to get more landlords to participate, so that you do an assessment of accessible units in the private market. Generally speaking, though, it also means an assessment of the units that you, the housing authority, are owning and maintaining, or you, the provider of Section 8 housing, that you are making available to people on your wait list. Many entities will designate a 504 coordinator, and it may be, because you're a small development, that it is the job of the manager of the development also carries the hat of a 504 coordinator. Or if it's a big development, it may be, a full-time or a part-time position. Certainly in terms of getting compliance, as Navneet mentioned, 504 requires that there be a grievance procedure for complaints, so that if somebody makes a request for accommodation, 504 applies, because this is a housing authority or a multifamily property, and that is denied, then the tenant is entitled to a hearing. And that hearing may be the standard process that the housing authority may have if it's public housing for their grievance procedures that they apply for everybody. It may be a special procedure just for 504, or it also may be looped into the requirement to for the interactive process, so that it may be one of any of those three elements, although the tenant is able to request, if they want a hearing, they would be able to request a hearing because you're required to have a hearing under 504. And that may work to the tenant's benefit. It may not be, because when you get into a hearing process, it's more adversarial. If you're in an interactive process, perhaps it's less adversarial and there's more flexibility in what the parties can negotiate. Another thing that, in terms of getting compliance, is to make sure that participants are aware of non-discrimination, that they're are given notice of their rights to a reasonable accommodation at critical times during the tenancy, so that if an eviction notice goes out, the tenant is informed that they may request a reasonable accommodation. If a notice goes out and saying you're being denied this housing, that in that notice of denial, as an applicant, that you're notified of your rights to a reasonable accommodation and to non-discrimination based upon a disability. And then, of course, the entity can adopt a reasonable accommodation policy. So what are some of the things that can be done in the admissions context? One I've mentioned already is affirmative outreach to landlords. Another is specifically marketing to individuals with disabilities. Some housing authorities may provide a preference for people with disabilities. You often see that, if at all, in the context of single individuals, so that if a single individual with a disability is preferred over a single individual without a disability. That's the way that I've seen it. I don't know whether anybody else has seen it in any other situation. Housing authorities, owners are urged to consider disability as a mitigating factor when determining eligibility, so that the applicant applies, the applicant has some adverse history, the applicant can request an accommodation saying that, yes, it's true, I have a bad rent paying history, and that's because of my disability, because I'm very forgetful, I don't show up for, I don't pay my rent on time, and so the accommodation could involve something with respect to, all right, we will notify a friend of the family if in fact you have not paid your rent after the due date, before we take adverse action. There's issues about rescheduling meetings, holding in the applicant's home or an accessible location. And one thing I do want to just mention, that even though we've been talking about accommodation, is just that I think that you will find perhaps in the fiscal atmosphere that housing authorities are facing now and that owners are facing now, there may be a little bit more pushback than you've seen previously, because housing authorities are saying, we're not getting the administrative fee that we used to get, or the level of administrative fee that we used to get for the Section 8 program. Our operating subsidy is now down and being offered at 81% of the statutory provisions, or the formula. And so that in the past, we were more quick to respond to your request for accommodation. We were more quick to accommodate, but we're feeling a bigger financial squeeze. And I only say that just in terms of if you're seeing that the atmosphere seems to be changing, and that also when you're making a request for accommodation, to try to figure out how you can do it at the least possible cost to the housing provider. There's certainly are always issues with respect to disability with alternative forms of communication, so that if the applicant is visually impaired, what kind of forms of communication can you provide to that applicant so that that applicant can have the full range of benefits of the program. And then, of course, there's always accepting cosigners for people who are low income because of disability. And there is a Ninth Circuit case with respect to that, where the individual had a disability, he had been working, he developed a full-blown case of AIDS, needed to move closer to family and to medical services. The provider said, your income is not high enough to afford this rent. The provider was using, I believe, a three times the rent standard for your income. But the court ended up saying that, a cosigner, and this was in private housing, even though the housing provider did not typically accept cosigners, in this case the court found that a cosigner would be appropriate and it would not be an undue burden to the housing provider. So then there's also issues interrelating with 504 in locating a voucher unit. Certainly, as I mentioned, a housing authority, if they have done the survey of accessible units, they should provide that current listing of known accessible units. Now, they're not required to do that kind of survey, but it is something that you could request of them. Maybe it's something that, to the extent that you become aware of those accessible units, that you can provide to the housing authority. Perhaps there are groups in the community that can provide that. Perhaps there's landlord groups that can provide that information. Certainly, most subsidized housing, in other words, Section 8 units, they were required when they were built to have accessible units. That information theoretically should be available to people in the community and available to you who are trying to find out where those accessible units might be. In terms of locating a voucher unit, certainly extending the search time for someone who needs a particular kind of unit because they're disabled. Now, whether that's a unit is for people with mobility issues, whether it's a person who needs to be located close to a medical facility, whether it's someone who needs a particular type of unit because they have chemical sensitivities and so only can be housed in certain kinds of units. There's also the increasing the payment standard for the voucher program. HUD recently sent out a notice in this year. I believe it's PIH Notice 2013-3 that empowers housing authorities to increase the payment standard for the voucher up to 120% without making a request to HUD. So it's within their ability to increase the payment standard, assuming that there is a need because of the disability. There also have been exceptions. There is a rule in the voucher program that says that you can't rent to a relative if you have a voucher. There is at least one case in which that I'm aware of in which a waiver of that particular rule was granted by HUD so that you could rent to a relative because of a disability. And the reason the individual that had the disability had to establish that there wasn't any other housing available that the individual with a disability could live in that would meet the needs of the disabled person. In terms of porting with a voucher, I'm not certain that there are any particular unique rules with regard to porting with a voucher with an individual with a disability, other than perhaps an individual with a disability may need more time to find a unit in another jurisdiction. In porting, that's what porting refers to with a voucher, is that if you port your voucher, it means you're taking your voucher from one housing authority and you're moving or porting into the jurisdiction of another housing authority. And certainly unit transfers, to the extent that the housing authority may have a policy, and many housing authorities now have a policy that says you cannot move more than once in a 12-month period. Let's assume, because of the disability, that the individual needs to move more than once within the 12-month period. And that might arise, let's say, because, again, you want to be close, the tenant needs to be closer to medical facilities, needs to be closer to family members that may be able to address some of the new or recurring symptoms of the disability. And so that,
Kathy,
yes.
just a time check. We have 5 minutes left.
Uh-huh. Okay, there's occupancy, unit size, extra rooms for, it's something you can request a reasonable accommodation. The HUD rules say that you must allow a live-in aid and that the live-in aid gets a room of their own if in fact the service is required for a 24-hour period. You must allow service and companion animals. You may be able to request and get an increase in the utility allowance, switching location of the unit from, let's say, the third floor to the first floor, or to a corner unit where you might be more isolated so that the behavior that's bothering other tenants won't bother, will be minimized, and for parking. Certainly in evictions and terminations, you can request a reasonable accommodation at any time, as Navneet mentioned, including after the eviction or termination has begun, and that a landlord must consider a reasonable accommodation until judgment of eviction is entered by the court. That doesn't mean that you should wait or that the client should wait or that the individual that needs the accommodation should wait until the last minute. It obviously makes it more difficult, but it is possible, and there's case law to support that. You can also perhaps reinstate a voucher or a tenancy because of that if it was taken away and the reasonable accommodation was not ruled upon and the tenant lost the tenancy or lost the voucher, you could ask for a reasonable accommodation to reinstate that. I'm not certain here in terms of examples whether we have time to go through these at this point. There are enforcement issues. Certainly one of the places to go for enforcement after you have tried with the landlord or with the housing authority or with the project owner is to go to HUD, and HUD will investigate, may issue, may take the case, may issue a ruling. You can also file in federal court. You can also file in state court. And here in California, you can seek a writ of mandamus. For contact information, it's on the slides here, and Carlo Ng is another attorney here at the Housing Law Project who is is in charge of the VAWA work that we're doing now. And she wanted to tell me that there is going to be a webinar on credit issues and survivors, and also a basic training, and that we will be seeking permission from OVW to do one on the new VAWA 2013 Act. And here's contact information for Navneet. And I'm sorry that Kim was not able to join us, but she may be able to assist us with answering some questions that you all may have as a result of the questions that were submitted during this session. I don't know, Navneet, whether you were able to look at any of the questions, whether there's time to answer any of them.
Yeah, there's a lot of good questions. I think some of them we're going to have to email responses to the group too, because they're a little bit more complicated. I actually have another meeting in a second, but I would like to answer some of the simpler, more straightforward ones. And also, someone shared a resource we can also send out. But Sarah Olasar suggested to people that if you go to socialserve.com, you can see listings for rental properties that have accessible units. But there's some of the one that I wanted to answer in the next minute or so was whether it can be an accommodation to port more than once in a year. And I think that's that's exactly the type of common accommodation you get with porting your voucher. So it's either needing to port in the first year of tenancy, where some housing authorities prohibit that, but in some cases for a person with a disability, they may need to port their voucher sooner than that, and also the person may need to port more than once in a 12-month period, and that is an accommodation that's been granted. And I think that we've, in doing advocacy on PHA plans, and we've been able to get a lot of housing authorities to specifically put that policy into their plans so that you don't have to deal with an accommodation request back and forth every time. Then there was...
There's a question here on portability that Shelter Plus Care doesn't port, and that's right. I mean, the portability issues are just limited to the voucher program.
So the other ones I think are require more in-depth answers, so we can put those together in a written document and send it out to people. Except for there's a question about whether the seminar provides CLE, and Cassie, I think that's a question for you.
Yes, and for those of you who are in New York, the word is green, and it's CLE for California. And for those of you from New York who contacted me before the webinar began. So thank you very much. As I say, I'm sorry that Kim was not able to join us, but you can tell us in your evaluation how helpful you found this, and we will try to address the questions that we were not able to address in a separate document. So thank you very much. And thank you, Navneet.
Thanks, Kathy.